Hi, I'm Anna Denton-Jones, and today I want to talk about tax and some changes that are happening in April of 2018, the 6th of April to be precise. The first thing to say about these changes is that it is likely to inflate settlement levels because if more money is potentially going to go to the revenue by way of tax, individuals will potentially want packages to be increased to reflect the amount that they're going to lose, if you like, in tax. So it's bound to have the effect of everybody trying to rush through settlements between now and the 6th of April. At the moment, we've got the 30,000 tax-free potential element if we are sure that no other tax rules apply. So we only ever fall into the tax-free exemption if we're happy that the sum of money that we're talking about shouldn't be taxed for other purposes. Now that general principle isn't changing, neither is the 30,000, you'll be relieved to hear, although the government is including or has included in the new legislation the ability to change that figure at some point in the future. I know there's been an argument for many years that 30,000 hasn't changed, certainly for as long as I can remember, so maybe it should. So no change there for now, but something may happen in the future. What is changing is the way in which we deal with pay in lieu of notice. And I know this can be something that is a little bit confusing for people. You're probably used to the idea that if there is a contractual pay in lieu of notice clause, then unfortunately we are bound to deduct tax from any payment in lieu of notice that is being made to an individual, including under a settlement agreement. I'm still surprised how often I see those rules being flouted. And in the light of new legislation which creates a criminal offence for individuals who encourage tax evasion, you've got to be incredibly careful now about flouting these sorts of things. You're probably used to the idea that if there is nothing in the document, so you've got nothing in the contract by way of pay in lieu of notice, technically the employer doesn't have the ability to make the payment in lieu. So we argue that any compensation that we pay for having broken the contract by doing a payment in lieu of notice becomes damages, and that can then become potentially part of the £30,000 that can be paid tax-free. That's often muddled, if you like, by automatic payment in lieu of notice. If there is a custom and practice within an organisation of automatically making payments in lieu of notice, irrespective of what there is in the contract, then potentially HMRC may decide that the payment in lieu of notice should be taxed. So that's kind of where we've been up until now. What is changing is a new concept of post-employment notice period. Is being introduced, and effectively whether or not the employer has the contractual clause, even if they don't, when a termination payment is being made, the law is going to attach onto the equivalent portion of the termination payment the payment in lieu of notice and treat it as taxable. So using a silly example, if I'm entitled to 1 month's notice and I'm entering into a settlement agreement, agreeing to bring my employment to an end, we know that effectively 1 month's worth of the basic pay equivalent of any termination payment that is agreed is going to be subject to payment in lieu of payment of PAYE and national insurance. So changing the position from what it would be now, where I might get that tax-free. There's obviously some rules about the calculations and the way in which that is done that need to be followed, which probably are too complicated to go into in a short little video like this. But essentially, the bit of a termination payment that relates to the notice period is going to have to be taxed. It doesn't stop things like statutory redundancy payments being paid tax-free. And it is possible that when we look at a global termination payment, that by the time we take off the element that relates to redundancy pay, for example, that the portion that we're left with is actually less than would otherwise have been paid for the notice period, and perhaps less tax is being paid than if somebody had worked out their notice. These are all things to look at on a case by case basis. This would also apply in a scenario I've just come across today, for example, a scenario where an adjournment has occurred, somebody is about to be, or potentially about to be, dismissed for gross misconduct, and the trade union have approached the employer in the adjournment and asked whether or not the potential dismissal could be avoided by having a settlement agreement. In that scenario, where there is a payment being made, whatever the employer decides to offer, again, the portion of that that relates to notice would have to be taxed. So I think you can see from that it's a real change from what we're used to, and that potentially individuals are going to end up with less money in their hands, and hence the driver perhaps to negotiate higher figures in the beginning, so that by the time the tax position has been taken into account, an individual is still happy then with what they do get in their hands. It is going to require us to change our settlement agreements a little bit, perhaps so that we express all of this in a way which HMRC can see what we're doing and that we've got it right. So you may need to think about that going forward. But as I say, 6th of April is the starting point for this. Dismissals and payments taking place after that date. If you do have any questions, please do not hesitate to contact me, adenton at refreshinglawltd, all one word, .co.uk. Thank you very much.